This topic that we are about to explore is a topic that I think is a critical one for those of us who are litigators, for those of us who are looking for ways to protect the public to an even better degree through the concept of efficiency and the concept of change. Judge Stevens, are you all right?
Sure.
Good.
Learning flexibility and change.
Judge Stevens she's a tough cookie. She definitely fits the bill. We've got a great panel here. Our topic is inefficient legal processes, resistance to change, and I think this is fascinating, and I hope you'll agree. Those of you who are virtually participating, this is a time to stick to your computer because this really is a topic on the forefront of many members of the profession. And law students, if you're wondering, gee, is this even relevant to me? Yes, it is. You may even offer ideas, and as always, please feel free to chime in with questions. Let me get started with a question that came to us online from an attorney who was participating virtually. She was good enough to send a question, and frankly, she's mad. And not only is she angry, her client or prospective client is even angrier. And what they're angry about is court processes. This will be a question for Marla. Quick comment before I begin. I failed to tell you who was on our panel. We have Daniel Linna, we have Marla McCowan, we have Judge Cynthia Stevens, and we have Bert Whitehead, all very knowledgeable about the various topics that they'll speak on. But this virtual caller or writer said she was angry, as was a prospective client, because the system is extremely inefficient. She had to, this lawyer who wrote in, had to show up for a hearing, and the particular court made her wait 6 hours. And she had to bill her client 6 hours. Why? Because she was devoting her time to the client. She apparently didn't have other matters in her briefcase to work with. The client was livid. The client said, I shouldn't have to pay for more than 1 hour. So we have a crossfire going on here. But at the very core of it, we have a court system that frankly offers lawyers or requires lawyers to do a lot of things that don't seem to make a lot of sense, such as show up for status conferences, wait for various motions to be called, but everybody's sitting in at the same time, sitting in the courtroom waiting. So I turn to Marla for just a question here. When we think about courts, when we think about technology, Marla, do you have any thoughts on some of the easiest ways for courts to use technology, not only to improve access to information, but also to improve the way that lawyers can serve the public, so that this lawyer, for example, who has to bill 6 hours, might find ways to serve that client, get the job done in less time?
I do have some thoughts. I don't know about, I'm sorry, I can't speak to billing, but I certainly can speak to the idea of many attorneys around the state who take assigned cases. And one common thing that I hear from a lot of attorneys, and in particular, I mean assigned criminal cases, adult felony criminal cases, those are the cases that our commission is charged to create standards to improve the practice for indigent defense delivery systems. And a question that I get from a lot of attorneys is about how much they are paid. And a question that I hear a lot about is, what can we do about, for example, courts that have something like a fee schedule or hourly rates, things like that. And I'm supposed to come to court for motion day, and I'm here all morning long, and I, can only, and then the case gets adjourned, for example, something like that. That attorney typically cannot turn in a voucher for sitting in court all day and get paid for that time. I do think that that's incredibly inefficient. And I think that there are some easy answers. I think that, first of all, that attorneys should get paid for the amount of time that they're sitting in court, especially if they're required to be there. That's a separate issue. We don't necessarily have to talk about that today. But in terms of technological solutions, I think that there are a couple of answers. I think that it's oftentimes easy for attorneys to call in, especially on maybe simple motions that are agreed upon. A lot of courts now, I go around the state, I haven't been in every court, but the vast majority of courts that I've been to have video conferencing capabilities. Attorneys don't necessarily have to be sitting in court all morning long. They can easily conference in, and I'm talking even about criminal cases, but mostly from the civil bar. I hear that too, that it would be just as easy for them to to video conference in or somehow not actually have to be present all morning long. And another very easy way, I'm always trying to think about things that could make things, a little bit more user-friendly for people who need to have access to the courts. I really think, ultimately, getting back probably to your original question about what are some of the easiest ways, I think people using email. Really, it's stunning to me to go around the state and talk to attorneys who don't have email addresses or who say things like, well, I don't do email, but my secretary does, or I've got some other people who do that. I mean, and I don't mean to be silly. I see some heads nodding in the audience. I mean, this is 2016, and this is a very efficient way for business to be getting done. And if it's something that can be stipulated upon or just easily sorted out without even having to be present in court, email. And I would even go so far as to say having an easy, low cost, but sort of workhorse of a scanner so that you can turn things into PDF documents and attach documents to email and send those around to email, PDFs, scanning. Some of those things are just the easiest possible way.
Good points. And Bert and Daniel, I know you've got some great ideas. Hold your thoughts, because I know you're almost offering where you would like to suggest where we ought to be as technologically advanced practitioners. But I'd like to ask Judge Stevens whether you think that the courts are part of the problem, in the sense that when we talk about inefficient legal processes, maybe there's not enough of a push from the state court administrative office on the trial courts to offer, for example, staggered motion calls, get some of the motions scheduled for showing up at 10 o'clock, the others 10:30, some later. What do you think the role of the courts, or perhaps our system of policing the courts, should be in helping ensure greater efficiency, if any?
Okay, the word policing is interesting. The word policing has a connotative meaning that I'm going to kind of reject here. I was a trial court judge for 25 years. The core problem is funding. Courts have the technology that they can afford. They can afford technology based upon the bizarre crazy quilt pattern of funding of our state courts.
But does it take...
So, just be clear. You have courts that are working with computers that are 10 and 12 years old. Even in the Court of Appeals, we've got iPads that we work from that have slowed to a halt. So when we talk about technology, a significant issue is funding. But that is not to say that courts can't be more efficient. Clearly we can. But what is more efficient depends upon a number of things. One of which is perhaps looking at, as opposed to policing, discouraging or repealing almost every local court rule. Because if we practice the same way throughout the state, hopefully a good way, at least lawyers can transfer from jurisdiction to jurisdiction with minimal difficulty. If we move the point of service closer to the point of the problem, i.e., if our small claims are done, frankly, principally out of kiosks at the library rather than asking people to come down to court, if we can afford kiosks so that, or systems where lawyers can handle early sessions of their cases from their desk, assuming those lawyers, of course, show up on time, it would work out better. But showing up on time, as we noticed earlier, was an issue. It's not just an issue with clients, it's an issue with courts, both the judicial officers and the lawyers in front of them.
Let's turn the mic over in a moment to Dan Linna. Dan, you are a guru of efficiency and systems, and you're also a former litigator, is that correct? So you've been at the end of the attorneys who are, like the person who wrote in, frustrated with the system as it is, but you're also now, as a law school professor, involved in legal R&D What do you think, what role do you think technology can play in streamlining the way lawyers practice and the way courts get their jobs done and their business concluded?
Sure. Well, there's been a lot of talk about technology, but where I really would like to see us focus is process first. And I'm definitely not going to take aim at the courts. I think there are things that can be done to improve efficiency in the courts, but I really want us to look at practitioners and ask ourselves, where can we improve? How can we improve the system? I think it's important to kind of reset and talk about the magnitude of the problem. And we've been talking, I've heard the term protect the public mentioned several times, and maybe not as much of an emphasis on serving the public. And just the magnitude of the problem and our inability to satisfy that goal when we have 80% of the indigent that lack access to legal services, more than half the middle class lacking access to legal services, and many businesses not getting the legal services that they need. And things have gotten so bad in the United States that when the World Justice Project ranked 99 countries on accessibility and affordability of civil justice, the United States ranks 65th in the world, 65th, tied with Botswana, Pakistan, and Uzbekistan. And I'm certain that we can do much better. Now, when we talk about technology, I think one of the difficulties we have is that in a lot of areas, most areas, we don't really understand what lawyers do to add value. And there's kind of like a joke talking about going to an associate in a large corporate law firm and asking, well, how many ways are there to do an M&A deal? The associate says, 12, at least 12. It's surprising. Well, how do you know that? Well, I've worked for 12 different partners and they all do it 12 different ways, right? And although we're better in some areas of practice, I think in the vast majority of areas, we really don't have standards. We don't have best practices. And without those, how do we actually leverage technology? How can we make the best use of technology when we don't understand what lawyers really do to add value? And it's not just the efficiency either. I'll just emphasize that it's not just efficiency, it's also the quality of the legal services that we provide that suffer when we have all this variance in the way that we perform legal work.
So where do these standards, where do these best practices come from? It's a nice concept, but what do we do with it, and where do we get it from?
Well, a lot of it is lawyers working together to develop these standards and best practices, and we've certainly seen that. I mean, examples of how that comes together are the different forms we have in different practices. And I'm sure there's room to improve in those areas and make them more user-friendly and to understand that we have self-represented litigants who are also trying to use those forms. So those are great examples of how that gets done. I will say that when I talk about lean, I think one of the things that's really important, a central tenet of applying lean is...
Wait, can you tell us what lean is? A lot of us here are uninitiated.
Sure. So lean process improvement, the goal of lean, and it developed from the Toyota production system and is very common now.
Briefly, of course.
Sure, in the automotive industry. And that causes lawyers to dismiss it maybe sometimes quickly when you talk about automotive industry, but it's becoming very popular in healthcare, for example. People thought at first that, well, rock star surgeons aren't going to be told that there's a process on how they conduct an operation, and in fact, that's what they're doing, that's what you're seeing, right? It's a method for getting the most value for the customer in the least amount of resources in the shortest overall lead time. And a central tenet of this is going to Gemba, is what they talk about. And that means rather than being in our offices, sitting around a table discussing what these processes should look like and how they should work, we go to courts and work with the staff who are delivering services in the courts. We go talk to self-represented litigants who are navigating through the process. We go to a law firm and we talk to the paralegals and the assistants and the associates and the partners to figure out how the process works and how it can be improved. So that's as concise as I can, an example of how lean can be applied. And one place, a great place to look for resources on lean is the Lean Ohio website. It's one of the best things I've seen to come out of the state of Ohio. There are a lot of resources there. Ohio, it's been a great initiative there to improve their state government by applying lean to processes, to courts, and in a lot of other areas.
Dan, you're talking about lean. We're about to turn over to Bert for just a moment, but when you use the phrase lean or the acronym, are you referring in a general way to business systems, a system about analyzing how we do business? And is lean just one of the ways that we can do this? I don't want people who are listening to come away saying, well, we must be focusing on lean. Lean is one of many different approaches, is that correct?
That's true. Lean is one of many approaches, and it's become very popular, and it's being picked up more in many areas. Entrepreneurs are using it for the lean startup method and things like that. The whole idea is business process improvement, looking at how do we really deliver services. This gets mixed into the alternative business structures discussion sometimes, because in law firms, for example, we often don't take the time to really think about how we deliver services because the incentives are misaligned. It's talking about, well, we need to take some time and spend some non-billables and understanding how we really provide value, looking at our processes, figuring out how can we get better, how can we understand our processes, and then the next step would be to take technology and improve those, to leverage those solid processes.
We have a question. Go ahead.
Good afternoon. Tim Hicks, Muskegon County Circuit Court. 2 points. The resistance to change, I think, is huge. As one who has tried to implement the changes in the way we do jury trials, you wouldn't believe some of the legendary arguments we have in my court. Number one. Number two, as I've been out of the practice for a long time, so in my ivory tower, I'm insulated from many of the challenges that a lot of you face. But whatever happened to the billable hour? When I got out of practicing a long time ago, I thought the whole financial system was supposed to move to flat fee stuff. So that may affect some of these inefficient legal processes and things like that. So I'd welcome your comment about that.
Well, I think one of the best people to offer a comment might be, and that might be a good segue, Judge Hicks, to Bert. Bert is here because he knows quite a bit about innovative law practices. And when we talk about alternatives to the billable hour, alternative fee structures, that's one of many ways that lawyers nowadays and firms are looking to change with the times. But with that in mind and considering innovation, what do you think that law firms and practitioners must do to adapt to a changing marketplace, which would include alternative fees or anything else? Give us your thoughts.
Thank you. The biggest issue is that law firms and the legal industry, the licensed legal industry, needs to start thinking of itself like other businesses. You know, there are manufacturing principles like lean, like centralization, like standardization on some things, but then customization like Vistaprint on others. There's supply chain improvements, all those things that many other service businesses and product businesses have many years adapted into their industry to figure out how can we do better in serving whatever our clients are, our customers. The legal industry has remained with old concepts such as partnerships and associates and many different things that just nobody ever picks that up. Nobody starts a business in any other industry and says, hey, let's have some partners and some associates and equity sharing that way. It's just we say, how can we do this in the way that everybody else does? So that's the first principle.
Give us some examples, Bert, of what you think would be an innovative law firm in Michigan, and give us some thoughts on that.
Well, as an example, the firm that I have, Access Legal Care, we took the principle, first of all, who is our target market? It's lower and moderate income people. Secondly, we said, okay, we have a statewide license. How can we be statewide? So we look at the goals that we have, and traditionally the challenge why law firms must stay local is because, well, I can't go to hearings in Iron County. I can't go to hearings in Traverse City. So that's just a challenge, an opportunity. How do we break that up? So we changed our business model and said we're going to be primary care attorneys. We're going to handle the whole case centrally from Detroit area for all kinds of cases across the entire state. And if we need hearings, we can use litigation attorneys, we call them, in other places to help with most of the hearings. And then at the end, if there is a trial, then the primary care attorney can do that. But by breaking that model up, using terms for the medical industry like primary care attorney, using litigation attorney so it doesn't sound like you're pawning them off on some other attorney, and saying, hey, this is a way that we can serve the whole state and be affordable for you, it allows us now to get so much more volume. As an example, going online with our presence, using practice management solutions like my case, Clio, Rocket Matter, et cetera, so that you can now communicate online with your clients, becoming paperless, scanning everything in and not having actually any client paper files, but everything goes online into box.com or Dropbox, into the practice management, shared with the client, shared with your other attorneys. basically turning yourself, looking at all these different things that how can I get higher volume, how can I lower my prices, how can I change from fixed prices to variable costs, and let me look at other industries. That's what we need to start to do to apply to our own practices.
Quick comment for people listening in. When we talk about all of the different things, Dropbox and the systems that are needed to run a practice, the State Bar, as many of you know, has the Practice Management Resource Center with 2 full-time staffers who work extremely hard, keeping up on a whole variety of issues and matters and information that all of us would need to know. So instead of reinventing the wheel, I encourage a lot of you to take a look at it. There has been some talk about the State Bar playing a greater role in helping lawyers at their desks and helping lawyers with technology. Bert, do you think that that would be a role that the bar should take, or do you think that that is a role best handled individually by the attorney?
It needs to be a centralized role. I think the State Bar is in a perfect position to have a resource center, maybe even an incubator law firm that puts into place some of the very best practices, best technology, best software, best models, allows maybe recent graduate law students to work in that, serve the public, maybe pro bono or low bono, but at the same time allow the rest of the bar to come in and learn from those, to come in and watch what's going on, see how they're set up, how do you serve clients across the state and in rural areas. I think that would be a great position for the bar.
Let's go back to the concept of efficiency, and the topic has come up about problem-solving courts. That came up at really one of the earliest stages with the Judicial Crossroads Task Force that the State Bar worked on. And sure enough, we have a variety of courts all over the state that are delivering very specialized service with specialized dockets. A question for Judge Stevens. What do you think about a statewide venue for specialized expertise judges and specially trained judges who can serve attorneys and clients all over the state? What do you think about that as a concept for more efficient delivery of service?
It's certainly another service model. And I don't know if we're talking about specialty courts or problem courts, because they're very problem-solving courts. The problem-solving court is an intensive team effort that would require that there be teams close to the point of service. A specialty court would be managing a particular book of business, and I think that they could be done a little differently. I hate to keep talking about money, but this is in part a monetary issue because of how we fund our courts. So if you have a special, quote-unquote, specialty docket, first of all, the question is, since we're trying to learn to be evidence-based, what evidence is there that we need a specialty docket for that, or specialty court? And if there is such evidence, that evidence probably comes from a stakeholder community, so the question is the extent to which that stakeholder community or persons addressing that community are willing to fund those courts. Otherwise, you've got a judge who is partially funded from a district control unit, partially funded by the state, servicing the whole state, and you have a fiscal nightmare. But it's the idea of at the very least, just as we're talking about having courts that cooperate and coordinate, as the Chief Justice talked about, under a single Chief Justice, having those courts create specialty divisions that service them. They've already got a local operating agreement, and you can have a local operating agreement to manage that specialty court without going into fiscal hell.
We've only got a couple of minutes left. I'd like to shift back to Dan here. We've talked, and you've talked quite a bit about business process analysis, the thought process that it takes to rethink the way you do things and to make things get done more efficiently. Do you think that it should be an issue for the task force in its report to recommend that all courts in the state of Michigan, state courts, should engage in some degree of business process analysis to improve the way they get things done and their efficiencies?
Absolutely. And that is something I think all lawyers should be doing. Again, I think this is a problem in the profession about understanding our processes and doing it in a way where you go to the local courts. And as a matter of fact, I've done a project with Judge Boyd and Judge Allen in the 55th District Court, where we went in and looked at the process for self-represented litigants to navigate the process. And we worked with the civil clerks there. We got together, mapped the processes, understand the process much better now, understand where there were areas where people inside the building maybe didn't understand how the process ought to work. It's something that should be done to deliver greater value. The key to it as well is that you can do it with paper and pencil. It's not expensive. It takes some investment of time, but it can pay huge returns on that time. I think sometimes we too quickly jump to technology problems when we don't understand the problem all that well. And the truth is that many successful technology projects, when you break it down and you look at it, a lot of the return came from a better understanding of the process and improving that process before you apply the technology. So let's carve out that piece. Let's look at our processes. Let's understand them better. Let's figure out how to improve them. Some may not need technology. Others then will greatly benefit from applying technology when we've improved the process beforehand.
With about a minute left, I'd like to turn the floor for a moment over to Marla, and I'd like to bring this to the level of protection of the public. I think in the end, what we're talking about ultimately, just as Bruce pointed out, is the mission of the bar in the protection of the public. But going to you, Marla, how do you think courts should balance efficient technology while ensuring that people's individual rights are protected? Do you have any thoughts?
I do, particularly in the criminal context. That's my world and what I know. I think there's an easy answer. First, I mean, we talk a lot about technology. We get excited about technology, and there's a lot of advancements. There's a lot of developments in technology being implemented in every courtroom. But and I think that's great. I think that's shown a lot of efficiency and cut a lot of costs. Even if there were some initial costs in implementing the technology, the long-term costs have been really demonstrated. But at the same time, I would just urge people to remember that there is a court rule in place when it comes to video conferencing in witnesses, for example, or also video conferencing with a defendant who's in custody. There's a very specific court rule in place that talks about how to analyze whether the defendant should be brought or needs to be brought, and those are based on constitutional rights, the right of confrontation and due process. So the short answer is that people should be paying attention to the court rule, but in the bigger picture answer is I think that we should continue to move forward and embrace technology because it really has shown to be a great thing.
I appreciate everybody's time and everybody's contributions. Thank you, panelists. And at this point, let's move on to the final panel. Thank you.